We don't normally think of liens as being discharged in bankruptcy. What's discharged in bankruptcy is personal liability. Now, this distinction between a personal claim and a claim against an asset is somehow, I think, for a lot of people, mysterious. So let me take a little sidebar to describe something that is unconnected to what we're talking about, and it'll help to set the conceptual stage. Let's say it's time to go buy a car. So you trot on over to the dealership, you see the car you like, and it's more than you can pay cash for. So what do? You take out a loan. When you take out that loan, two things happen. Now, they happen simultaneously, so you might not think of them as two separate events, but for this purpose, it's handy to bifurcate them into two separate events. Number one, the creditor has a claim against the car, meaning if you don't make the payments, the creditor can repossess the car. So what have I just described there? Well, it's a claim that the creditor has against a physical asset. In law, we refer to that claim as an in rem claim. And the reason for that is the Latin word for thing in the objective case, the appropriate objective case, turns out Latin has a couple, is rem. Now, the second thing that happened when you bought that car and took out that loan is the creditor got a claim against you as a person. What does that mean? Well, it means that if you don't make the payments and the creditor repossesses the car and turns around and sells it for less than you owe, the creditor can come after you to collect the post-resale deficiency. So that's a claim against you as a person, so it's referred to as an in personam claim. So to summarize, you don't make the payments, the creditor can repossess. Claim against the res, an in rem claim. If they come up short, they can come after you to collect against you as a person, the in personam claim. So a lien then is an in rem claim against the asset against which the lien has been recorded. You have an in personam liability as well, because if the creditor got a judgment against you to record the lien, they must have asserted and successfully prosecuted their case saying that you personally owed them whatever the dollar amount is. When you go through a Chapter 7 bankruptcy or a Chapter 13 bankruptcy, the goal ultimately is to discharge in personam claims against you. It does not get rid of in rem claims against assets. So for example, if there's a mortgage against your house, you're not going to get a free house by going through a Chapter 7 bankruptcy. If you could, everyone would buy a house and the next day file for a Chapter 7 bankruptcy. So that you don't get to just get rid of. Now, the bankruptcy code does have a provision that says that you can remove a judgment lien to the extent that it impairs your exemption. Now, what on earth does that mean? Well, the case has to be pending, and whatever this asset is, you have to be able to exempt. So there's a formula given in the bankruptcy code to determine whether a lien impairs the exemption or not. Let me take a little bit of a sidebar to talk about what I mean by exemptions. This is best understood within the Chapter 7 context because exemptions have a different purpose in Chapter 13. So in Chapter 7, since debts are being wiped out without you paying anything at all, there are some limitations. One limitation is on what you get to keep. You get to keep some stuff, but there's at least the potential to lose assets in a Chapter 7 bankruptcy. So one of the things we include in a set of Chapter 7 bankruptcy papers is a complete listing of everything you own or have an interest in. And all of those assets get divided into two categories: exempt, non-exempt. The exempt stuff, that's yours to keep. The non-exempt stuff is fair game for the Chapter 7 trustee appointed to the case to seize and liquidate and have money to distribute to your creditors. We determine whether something's exempt or non-exempt by appealing to one of two exemption tables. In California, we use two state tables. Although the bankruptcy code does have an exemption table itself, it does allow the states to use their own state tables. So in California, we've got 2 state tables, one for homeowners with equity, the other for everybody else. Each table has a list of various categories of possessions. In a Chapter 7, as we prepare the papers, we list your assets and we stick them into these exemption categories to the extent possible to protect them from the depredations of the Chapter 7 trustee. Now, let's say that among those assets is your home. So we're using the homeowners table. And there is a lien recorded against the property. And it's a judgment lien. This concept that I'm describing here does not apply to other kinds of liens. It's specific to judgment liens. So those are those liens. Remember that someone has sued you successfully, gotten a judgment, recorded a lien against the asset. And in this case, we're going to think of it as the real estate. Well, we can avoid, somewhat unusual usage of the word avoid, it means to render null and void. We can avoid that judgment lien, as I said, to the extent that it impairs the exemption. How do we determine that? We take the value of the lien, whatever the dollar value is. We add to that the sum of all other liens and encumbrances against the title, whether it's mortgages or other judgment liens, whatever it is. We get a grand total. To that, we add the exemption amount that you would have been able to take if there were no liens. And now we have a number, the sum of the liens plus the exemption amount. To the extent that it exceeds the fair market value of the property, to that extent, the judgment lien impairs the exemption. And to that extent, you can avoid it, remove it. Now, you have to do that during the bankruptcy case. But if you do that, then there is no longer that in rem component to the claim. All it is in personam. And as long as the underlying debt is dischargeable, once you get your discharge, that debt gets wiped out. The lien is also gone. And now you're free and clear from that creditor associated with that judgment. In Chapter 13, you can do the same thing. The idea of exemption is a little bit different in Chapter 13 because unlike Chapter 7, you get to keep all your possessions. But the value of the non-exempt assets is still important because it's used to determine the minimum that you can get away with repaying your creditors over the life of the Chapter 13 plan. In any event, you can get rid of a judgment lien to the extent that it impairs your exemption, but we don't really use the word discharge in this context because discharge is really associated with getting rid of the in personam claims.